Are you caring for your elderly parents? Welcome back to our Caring for Elderly Parents checklist series. I'm Tamara Berman.
And I'm Ozzy Martinez from Century 21 New Heritage.
In an earlier video, we talked about helping elderly parents compile a checklist or binder to include legal, financial, and insurance documents, as well as medical information and end-of-life wishes and directives. Today, we are with Rick Biasca, attorney with Biasca Law, located in Huntley, Illinois. Rick is with us to discuss the legal documents that he recommends that we all have in place as we age.
Welcome, Rick, and thank you for joining us today.
Thank you for having me. I appreciate it. All right, so it's important for everybody, in particular those who are advancing in age, to get a proper estate plan in place. The estate planning package will typically consist of a will or a trust, a healthcare power of attorney, and a property power of attorney. So we start out with the very basic, the foundation of the package, which is a will or a trust. The will or a trust depends on your particular situation. I'm a big advocate for making things as simple as possible. A will, there used to be some tax advantages to doing a trust versus a will. That's not so much the case anymore. So what we really look at it is from an angle of, does the estate need to avoid probate? So what we would typically do is take a look at a particular person's situation and then determine if there's any assets that potentially could take that individual into probate court. And of course, to make things simpler on the executors on the backside of things, we make the determination up front on whether or not a will or a trust is appropriate. With a trust, there's kind of two steps to it. We need to put the document together, and then we also need to make sure it's funded, which means placing assets into the trust. For most people, what brings probate into play is if somebody owns real estate, particularly in their own name. So in that particular situation, I typically will recommend a trust, again, with the eye on avoiding probate on the backside. If that's not really an issue for the individual that I'm working with, a will typically be fine. There are some exceptions to the probate rule. So if the estate's of a smaller size, there is a way to potentially avoid probate, even without having a trust in place. So it really depends on an individual's particular situation. The other advantage or benefit, I guess, of doing a trust versus a will is that the trust is private. It doesn't get filed anywhere. There's no court intervention. For a trustee to take action under the trust, there's no authority required from anybody else. Basically, the trustee could step into the person's shoes on day one and do whatever they need to do to administer their estate. So, again, it's a pro or a con, just depending on a person's particular situation. But that basically forms kind of the general foundation of a person's estate plan, again, either being a will or a trust. So taking us to the next document that forms a solid estate plan will be the powers of attorney. There are basically two powers of attorney that come into play. The first one is a property power of attorney. The property power of attorney is while somebody is living, but mentally or physically unable to handle their assets. So with the power of attorney form, it's a statutory form, it's for Illinois, and you basically will appoint a successor power of attorney in addition to people behind that person, to step into your shoes and handle bank accounts, homes, real estate, life insurance policies, anything basically that has to do with anything other than healthcare. And your power of attorney could step into your shoes, again, in the event that you're physically or mentally unable to handle your affairs. Those expire at death. But they are good while you're living. There are some particular provisions that you could put into play. I typically suggest that they be left as open and broad as possible, meaning that they are effective the date you sign them, and again, they don't expire until death. I also don't recommend that there's any type of triggering provision in there, and what that means is if you become incapacitated, you can require that for a power of attorney to step into your shoes, they need to first get a doctor's certification that you're in fact incapacitated. What I have found is that just adds another layer for your power of attorney to have to overcome when maybe some things have to happen fast, and it becomes a challenge to try and get that doctor's certification and things need to get taken care of. So my suggestion always is that you have the property power of attorney written broadly, effective at execution, and expiring at death with no type of triggering provision. which then allows your power of attorney to take action the day required without any type of doctor certification. And last but not least, in the estate plan is a healthcare power of attorney. Similar to the property power of attorney, the healthcare power of attorney is also an Illinois statutory form, and basically this deals with your healthcare. Basically, if you are unable to make healthcare decisions, you are again appointing a power of attorney to step into your shoes and make those decisions for you. Obviously, it's extremely critical that the person you appoint is somebody that you trust because your healthcare is in their hands. Similar to the property power of attorney, again, these documents are effective at execution and they expire at death. There are some provisions in the healthcare power of attorney that deal with the life support decision. There's 3 paragraphs in particular that you'd have to read and initial by the one that you agree with, basically, and how you want that decision handled in the unlikely event or the unfortunate instance that becomes an issue. So you're basically giving guidance to your power of attorney on how you would want that decision handled. And again, you definitely want to make sure that person that you appoint is somebody that you trust with your healthcare. It's a difficult situation, of course, and a difficult decision to make, but it's definitely important that you get those in place. Once you have it in place, it's always a suggestion to provide a copy to your doctor so they have it on file for you. If there's an emergency or a healthcare decision that has to be made quickly, at least the doctor has a copy of that as well. But other than that, you'd have a solid estate plan with, again, the will trust, the property power of attorney, and the healthcare power of attorney.
Thank you so much, Rick. We appreciate you taking the time to give us the details of our legal checklist for aging parents.
If you are working to put important information together for yourself or your parents and need a guide or have any questions, reach out to us. We'd be happy to connect with you.
And don't forget to like and subscribe for future videos.